Welcome to the Truth Champion Podcast with Ashley Yablon. Join us as Ashley taps into his wealth of experience as a lawyer, a leader, an educator, and an author to inform and inspire others. Listen as Ashley unpacks the real-life implications of standing for what is right against all odds, the pitfalls of blind ambition, and above all, the need to be careful what you wish for, because you just might get it.
Welcome, everyone, to the Truth Champion Podcast. My name is Ashley Yablon. Usually you hear Paul as our host. Today, we're going to do things a little different. I am your host, and I have invited a colleague of mine, actually a very good friend of mine, a fellow attorney who is a partner at one of the largest law firms here in Dallas, Foley. So I introduce y'all to my good friend, Rob Slovak. Hey, Rob, how are you?
Fantastic. Thanks for having me.
Yeah, thanks for coming here. You know, as I was getting up this morning, I was trying to remember how long you and I have been friends. And I started putting time together, and I realized it's been really over probably almost 2 decades that I've known you. I think it was back in the time that I was with Huawei. And I think we became friends. We met through a mutual friend of ours, but I was thinking, my gosh, I've known Rob for quite some time.
Yeah, I don't know if that's a good thing or a bad thing for you.
Exactly. And as we were talking just before we started here, if it sounds like I'm on my deathbed, I'm not. I have some kind of virus, and you're mentioning that it kind of swept through your family as well, right?
It did, but that's the natural consequence of attending a cheerleading tournament in Houston with thousands of young cheerleaders running around spreading disease.
Was that this last weekend?
2 weekends ago, yeah.
Okay. All right. Well, we're doing this on January 3rd. So just got done with the New Year's. Did you have a good New Year's? You do anything fun?
Not anything too exciting. We got a 13-year-old and a 10-year-old, so we like to hang out with them while they still like us. So we went to dinner and had some prime rib and came home and watched the Dallas celebration.
Yeah, very good. Well, I did mention that you are a partner with Foley, so I'll let you kind of give a little background of you and let the audience get to know Rob Slovak a little bit.
Okay. Well, as you mentioned, I'm a partner at Foley & Lardner. I've been there now for 22 years. The firm itself was originally in Dallas. It was really focused in Texas, Dallas, Austin, Houston, Mexico City. About 4 years ago, we were part of a merger combination with Foley & Lardner, which took us from a 250 lawyer enterprise to about a 1,200 lawyer enterprise. And I do what I characterize as business divorce. So if there's a fight between partners, if a stock deal goes bad, if somebody steals trade secrets, then I typically get involved in those particular fights among the business partners.
Okay. And, I know you, and you're being very humble, but you pretty much run the litigation department for all of Foley, don't you?
I wouldn't go that far, but I'm a national vice chair of the litigation department at Foley. So it sounds really important, but, I'm not sure that it's as prestigious as it sounds.
Well, it sounds very prestigious. And you mentioned earlier about your family, so kind of give us a little bit about your wife, your kids, and all that good stuff.
Okay, my wife Jamie and I have been married now 16 years. I have a 13-year-old son whose name is Braden, 10-year-old daughter Emma, and they are sort of the central focus of our time when we're not working. My wife recruits lawyers for a living, and that's how we met, actually working at Gardier. And so 16 years go by, and it's all working really well for us so far.
Yeah, your kids are great, and Jamie's awesome too. And a fun fact, Rob and I share this interest, and that is cooking and actually doing barbecue. We have a crazy story we could tell about a barbecue boot camp that we attended together and the crazy stories that came out of that. But one thing that you do, and I think is so cool, and I've actually been to it, is you do every Sunday night, you do at the Slovak house, it is steak night. and you cook out steaks. And let me tell you, folks, he is a fantastic griller of steaks. You're still doing that, right? And I don't know why I haven't been invited over in quite some time.
We do. Yeah, it's an open door policy at the Slovak household. So anyone who wants to come on Sunday night, show up. We have we use it as our family time, and then our time to bring friends and coworkers and people together and socialize. So we like to do it. I don't have that many talents, but grilling is one that I take pride in.
Yeah, and you're fantastic at it. So yeah, that's a fun fact. All right, well, we've titled today's episode Best Practices in the Legal Profession. You and I have kind of touched on it before this, but we kind of didn't go into very many specifics because I wanted us to kind of have a frank discussion, make it more open-ended. But one of the things I did want to talk about, because in the previous podcasts, as well as what's referenced in my book, is I talk about the differences between being what I ended up being, which is an in-house lawyer or a general counsel, versus being a lawyer at a law firm. And, obviously you're a good friend of mine, but the part of the reason I wanted to bring you here is because you've always been at a law firm. You started off at what was Gardier, and then continued on and have been there. You even started there as a clerk, right? And it kind of explained to people what it means to be like a law clerk, and then doing that during law school, and then hopefully getting on to become an associate at a law firm.
Yeah, I mean, law school is a 3-year process, and most people have a major clerkship in the second year of law school, the second summer of law school. And if it goes well, then that ends up being where you go to work when you get out of law school. So by most folks, I wouldn't say necessarily all folks, but a significant number of folks have their job secured by their 3rd year of law school. And so when I clerked back in the day, I feel like an old guy now, but everyone did 2 summer clerkships, or tried to do 2 summer clerkships at 2 different firms. My first year I spent at the Court of Appeals down in Houston, and then worked for a plaintiff's firm, and decided that Houston was not going to be my place. And then I clerked at a big multinational 4,000 person law firm half of the second summer, and then Gardier the other half of the second summer. And Gardier at the time was a regional firm, and that's where I felt like I wanted to make my long career, and it's worked out well for me so far.
Yeah, and Gardier is here in Dallas, and I guess throughout all of Texas, it's well known. I worked for so many attorneys when I first started who got their start at Gardier. Everyone seemed to work there. You and I have talked about all the people we know who were alumni of Gardier. So
it's like 6 degrees of Kevin Bacon.
Yeah, exactly. That's exactly what it is. So yeah, I kind of wanted to explain a little bit about the difference, and you tell me what your thoughts are on the difference of being an in-house lawyer. Again, I know you haven't done that, but kind of explain to people out there what it's like working at a law firm. Obviously, you started at Gardier as a clerk. You got on there as an associate with the goal of a partnership track, which everyone tries to do. You were obviously very successful at it and made your way to partner. So kind of explain that, kind of the process of what it means to be on a partnership track. And then we'll get into other things as well. But I kind of want the audience to understand what it means to be an associate and what that means at a big firm like Gardier, or now it's Foley.
Well, I mean, as an associate, we call it the practice of law, because you don't come out and know much about law. And so it really should be characterized more as an apprenticeship, or many people debate this, whether it should be more like medical school and you should be required to do a residency. But for all intents and purposes, your beginning of your career as an associate is like an apprenticeship in many ways, except you're being paid handsomely to do it. And you still have all the same ethical responsibilities and duties to your clients, as well as internally to your partners who you treat as clients. But the goal really is to, in a larger law firm that like ours, associates are used to do some of the daily kind of work that they can do very efficiently and very effectively but a little bit lower billable rate. And your goal as an associate is to continue to progress, learn the trades, diversify your skill set as much as possible, depending on whether you're in litigation or transactional practice, which is sort of the big divide in the practice of law. And you hope that you gain enough experience and diversity throughout the advancement through the ranks to also focus on developing your own clients and expertise so that you are invited into the partnership. And, one thing that I tell young associates that, whether it's, they may think it just sounds like the old man, but oftentimes associates come in with their goal, primary focus is to make partners. And what I tell them is I think that's a little bit short-sighted, because typically you're going to spend a far less significant portion of your legal career as an associate as you are a partner, right? I mean, in my case, it was 8 years as an associate, and now I've been practicing for 22. And so, that you were really looking for, and you should look for, a place where you can be at home, comfortable, work with a team and an enterprise that you like as a partner, as opposed to your focus being, am I going to have a happy life as an associate?
Yeah, that's a good point. And the other thing that you mentioned was, obviously, as an associate, you're almost doing 3 different things at once. It's obviously you're trying to learn the trade. You're trying to, let's be honest, bill hours, because that's how a law firm stays in business. But then the third part that you mentioned, I think this is the hard part for an associate who's still learning, still trying to do the hours, is to build their own business, right? And I think you mentioned that before, that's also what I guess the firm would look at as they're looking for someone to be a partner. And so that to me sounds, well, I know it's very difficult to try to be building clients, build clientele, while also learning the trade as well as getting those requisite number of hours. Would you characterize it that way?
The hardest thing about being a lawyer is developing business, because it's in many ways it's sales, but it's a relationship business. And so you asked earlier about the difference between in-house lawyers and outside lawyers. Like, as the in-house lawyer, you are our clients, right? We spend our career trying to make you look better and working hard to understand your businesses, what those businesses focus on, what's important to them, and how to partner with those businesses in order to make them successful. I say often, and I'm not sure that, I don't know that everybody agrees with it, but I think most people don't want a long-term sustained relationship with a trial lawyer. Generally, if they're contacting me, it's because something has gone wrong in their business.
Right.
And on the transactional side, where they're closing deals and buying companies, or selling assets, or entering into contracts that develop revenue, it tends to lend itself more to a daily or more consistent interaction. And so the way that you develop your career as a transactional lawyer versus a trial lawyer are different. But fundamentally, it's about having a personal relationship with the people like you that need outside counsel to help make the business work.
Yeah. And it's so funny you said that. And in full disclosure, yes, when I was general counsel, I hired Rob to handle and assist on a few matters. And you just said something that I had forgotten that you said then. And when you said it now, I remembered you said that was, my job is to make you look good. And I remember you saying that. And it's something I've always respected, and you've done that. So yeah, that's a good point. Thank you for clarifying that, because I wanted people to understand the fundamental difference between in-house lawyers, where I just have one client, but I do all kinds of law for them or manage that, versus you who have many clients and you specialize in, like you said, the business litigation, the divorce of companies, the divorce of people within the companies, and how that manifests. So going on, again, the title of today was Best Practices. Now that people kind of understand a little bit about the differences, between in-house, also working at a law firm, and then what it means to work your way up to be a partner, and all the effort that takes. One of the things that I wanted to talk about today were some of the challenges that you see. Obviously, a lot about what I've spoken about on this podcast, as well as what's detailed in my book, are the pitfalls and challenges when I, as an in-house lawyer, have issues with my one client, and what that means. I wanted to kind of open the floor to you, and you as an attorney at a law firm. You have many new clients that come in, and some of the challenges that you've had, maybe some things that challenged you ethically. And again, you and I purposely haven't talked about this because I just wanted you to free flow and give, again, without naming names, because we don't want to waive any privilege or anything like that. But if you could give maybe an example or two of a challenge that you had with a client from an ethical perspective, and what you did to try to get around that, or keep ethically correct as an attorney, and what you did.
Well, here's oftentimes, at least in my experience, clients want to hear what they expect to be the right outcome. Right.
Right.
And so, I mean, the challenge is to be good at this job and to do it well, is that you need to be able to be critical and honest with your clients, even when you're delivering bad news. And you have to avoid focusing entirely on the risks, but because there is significant risk in at least at what we do on the litigation side, you have to be honest. And it does at times require you to say things that are not going to be well received by your clients.
Right.
And you have to stick to your guns and be forceful about it. I mean, you asked about an example. I can give you a fairly specific example of a case that went on for about 5 years, and it was a accusation of misappropriation of trade secrets, which is a fancy way of saying that someone's accused of stealing the secret sauce from another company.
Right.
And there was a particular witness in the case that the story about why they had in their possession some information morphed along the way. And to the witness's credit, over the passage of time, memories fade, and the emotional aspect of being involved in litigation. Part of the reason we call it business divorce is because people get very emotional about it. Like you would a divorce from a spouse, particularly if it's a business that you were intricately involved in. So to their credit, the diminishing memory over time is something that you expect. But when the story changes, and you are asked when you are preparing witnesses to testify, as I was in this particular case, what should I say? And as a lawyer, you can't coach your witness on the facts. I mean, the facts are the facts, and so in this particular circumstance, the answer was you tell the truth, right? And when pushed, and it was, well, which story sounds better, right? And the answer is the truthful story sounds right.
Right.
It's the only story that you can tell, and I can't ethically allow you to tell anything different. And so, that's, I wouldn't say that happens commonly, but it is a difficult and challenging situation that I have encountered specifically. And the way I dealt with it was to simply stand firm and say, you have to be truthful. There's no other option for you. And juries do a pretty good job, in my experience. Juries and judges do a pretty good job of cutting through the crap and really right. discerning whether they believe that someone is telling the truth. And that's their focus, and that's what the system is designed to allow people to judge the credibility of witnesses. So the truth is always the easiest way to come across as credible.
Yeah, no, that's you're spot on. So in that instance, do you feel like as you were prepping that witness and then they went to go either testify, whether it was a trial or a deposition, did they end up saying what was the truth versus the alternate that they'd come up with and presented to you?
Yes. That's the short answer.
Yeah. One of the things you had mentioned before, and I wanted to kind of come back to this, was the issue of setting client expectations. And you mentioned earlier having a lot of times to give bad news to a client. Obviously, a client comes in, and you can talk about this a heck of a lot more than I can, but a client comes in, tells you the situation, and then wants an answer. And of course, you as the attorney, as also a business person, you want to make them feel comfortable with you, give them a good scenario, but also, I said before, you got to balance it with setting client expectations. And a lot of times that's telling them things, like you mentioned earlier, they might not want to hear. If you don't mind, if you have an example or can think of one of a situation where a client comes in, tells you the scenario, and you try to level set the best you can, but you're also knowing that they're not going to like to hear the answer, which is, we're not in a real good situation here, and here's why. Have you experienced that before? And if you have, what has that been like? And what was the reaction of a client?
I mean, you experience it frequently in the civil litigation world, right? And, you know, the difference between the civil system and the criminal system is in the civil system, you're fighting over money typically,
Right.
as opposed to fighting over liberty. But people have this misconception that the justice system is about justice. And in the civil litigation world, it's not always that way, because the expense associated with getting a case to trial is really high. And so in many instances, people want to fight for principle. And as a lawyer, you respect that they want to fight for principle, and you want to be the champion for those principles. But you have to be very sober in your discussions with them about what that means, right? And so, you know, not a specific example about a particular case that I could reveal, but if there's a dispute between the parties where the amount in controversy is, you know, call it $3 million, $3 to $5 million. In my world, in a state court case or in a federal court case that has substantial discovery and multiple witnesses and anticipated battles over getting documents and the kinds of things that lawyers skirmish about, you can reasonably anticipate that you're going to spend, you know, $750,000 to $1.5 million to get that case to trial. And so you have to have sober conversations with your client about that balance of risk and reward. You know, if the upside is potentially $3 million, but you're going to spend $1.5 million to get there, and you're going to have to deal with all the distractions from the things that make you good as a business, because you've got to spend time giving depositions and working with people to gather documents. There's an opportunity cost associated with that investment. So I have a lot of sober conversations with clients on a frequent basis to say, you're right, and your principle is a well-founded principle. But if you go down this path, you're going to end up in a situation where even if you're victorious, you may not feel victorious, because you've spent, you know, $1.5 million to get a $2 million recovery, and it's going to feel hollow and pyrrhic. And so you have to have those conversations quite frequently to level set expectations.
You know, the title of our episode here is Best Practices in Law. And I think you just hit the nail on the head, which is being an attorney, and being a good one like yourself is being honest. And it's not just being a lawyer, right? We all go to law school to learn all those things and that. But you also mentioned at the beginning, it's the practice of law. And part of that is having those sober conversations with a client and saying, like you just did, my goodness, you're going to spend half as much as the value of this case. And so then at that point, you become the business person, right? And I think what you did, and I, as we sat here, I'm remembering these same conversations that you and I had about some of the matters that I had asked you to assist me with. And I think that's being an ethical person. You are and have been and always were when we dealt together in my matters. But what you just explained is something that people don't understand about lawyers. They think we just go to court, that we just file things and magically clients have endless pots of money. But what you just described was being that business person and having those sober conversations where it might not make sense and justice isn't found completely in the justice system. Sometimes you just have to make those business decisions, and that's what a good lawyer does.
Yeah, I agree with that. But I wouldn't want the audience to believe that the justice system isn't just. It is, and it works very effectively in my experience. But the civil justice system, where people are often fighting over these kinds of business disputes, fundamentally, it's not designed so much in the outcomes that you get out of it to prove right or wrong, right? Because it's an economic process from beginning to end, and so people have to understand the playing field and what the potential outcomes, both good and bad, are in order to make a well-reasoned and informed judgment, and not simply go into the litigation with an emotional expectation. There's a lot of emotion involved in these fights, as they often are. That's why you get to the point of hiring a lawyer in the first instance. But rational decision making in business requires a balance between those emotional responses and what's in the best interests of the enterprise and the individual that's running the enterprise. And so you just have to figure out how to balance that and how to articulate it in a way that instills confidence and trust. And you can only do that if you have the experience and the street credibility and level of candor, I guess, is the way I would put it. You have to be frank with people about what those risks and benefits are. Sometimes you talk yourself out of more work than you get.
Right.
In that circumstance, but that's your job, really, is to help other people assess the risk and understand it.
We've talked about, helping the other side, helping your client understand the risk and being ethical. Sometimes that means letting a matter go or not fighting it to the hilt. I think I know the answer to this, but kind of tell the audience, have you dealt with a matter where you're assisting, you've been candid with your client and you've level set their expectations, but on the other side, you've dealt with an attorney who really wasn't that way, had maybe not set the expectations well with their client, and we're going to bill them to win that, principled thing that they said they wanted to do. In other words, they hadn't had that frank discussion with their client and were out to spend, which I would think would require that your client has to spend money to keep up as well. Have you experienced that from other lawyers on the other side?
All the time. It's, there's a reason why people don't like lawyers. There's a lot.
I don't either.
There's a lot of them that are difficult to deal with. And there's a lot of inherent possibilities for conflict of interest. I say this to young lawyers all the time, is I would much rather deal with an adversary who's smarter, more prepared, and better at their job than I am, because it makes the experience better overall. If you can avoid fighting fights for the sake of fighting fights and sort of cut to the heart of what the disputes are. And so, those kinds of situations happen all the time. I can think of several off the top of my head, but where I have found that it often, the level setting comes is if you get to mediation with a neutral third party, experienced judge, past judge or lawyer, where you were in a brokered settlement discussion where the professional basically plays shuttle diplomat. That person oftentimes has the ability to level set in the other room, and so I can think of a case really in the last couple of years that I dealt with where it seemed fairly clear to us that the other side was hearing only the upside and not the downside.
Right.
And we ended up settling the case out of mediation, and I credit the mediator for having the conversation that maybe the lawyer on the other side had not had with their client to bring a sobriety about the risk, as opposed to that it was always going to be a win. And so sometimes you have to use those tools to educate the other side if you can. It's very ineffective. You can't speak to their client directly. And I have found that simply telling the opposing lawyer that they're wrong rarely does much good.
Right. Yeah, that's what I was going to ask you, because obviously we'll talk about mediation here in just a second, and that was a great point. But you have tried to have those candid discussions by calling the other side and saying, hey, listen, let's be honest about your case. Here are the pitfalls I see. Have you had open, honest conversations with your client about the potential items that might not be able to get their case across the goal line in the manner that you have explained it to them? And I'm sure you have. Does that happen a lot more often and than most people know about?
It does, but it goes back to what I said before. It depends on the adversary, right? I mean, I find that if I'm dealing with someone on the other side that is experienced, sober about the assessment of risk, and really has a meaningful relationship with their client, those are much more effective conversations. And when I say meaningful relationship with the client, those take many different forms. But if someone has worked with a particular client for a long period of time and has a little bit more trust, it's not the first dispute that they fought with that particular lawyer. I have found through experience that oftentimes those lawyers have a little bit more influence early on in the decision making process of their clients. It also largely depends on the client experience with, at least in my world, with litigation, right? Because if you have never been in a lawsuit as an advocate and you've only watched television lawsuits, it just doesn't work that way. The civil justice system is not what you see portrayed in on television or in movies. It doesn't work like that. And so there's a requirement for people to educate clients on what the real world, I guess, is like in order to have a meaningful dialogue. And so some lawyers are really good at it. Some lawyers are very natural at it. Some lawyers come at it, more slowly. It's one of those situations where it depends, but we try, at least most people in my profession that I've dealt with over the years, try to have those conversations early and often, try to level set the playing field of the other side to say, look, there are certain things that we may have to fight about, but I would appreciate it if you would pick up the phone and call me before, you make a move that might be perceived as overly aggressive or, may fuel an otherwise, sort of less virile fire. And so, you try to have those conversations, you try to establish that relationship with opposing counsel. And sometimes it works really well. And sometimes there are certain personalities that are attracted to litigation where they just want to be disagreeable. And so, inherently you're going to have a difficult time having the honest, candid dialogue that you sort of described. But in my experience, it's just much more pleasant if you were able to have that level of collegial interaction with your opposing counsel, because you can cut through the rest of it. You can fight the fights that really matter, sort of decide which witnesses you actually have to depose versus those that you don't, not fight about the kinds of things that tend to run up costs and further animate, clients' emotional responses. So I'm optimistic when that dialogue exists, and more often than not, you solve those cases as opposed to having to push them all the way to trial. But sometimes the cases just have to be decided by a neutral third party.
Yeah, through a mediation, you're right. Yeah, you can only try so much on your own by having those candid discussions. But like you mentioned, mediation a lot of times is the best route. And then sometimes even after mediation, you still can't get resolution, and then you have to go to a trial. So, well, we've talked about a lot. We've talked about what the difference is between in-house, what it means to be a lawyer at a law firm. You've explained everything about the associate life, the track of being a partner, and then some of the challenges and pitfalls you've had in best practices and ethical issues with clients. So, Rob, I can't thank you enough for coming here. Thank you for being a part of this podcast, which was called Best Practices in the Legal Profession. If anyone needs to get a hold of you or needs services, hopefully, like you said, they don't want to go through a business divorce, what's the best way to get a hold of Rob Slovak?
Well, hopefully they're thinking about me to enhance their business, and I'm there if they get into a fight.
Very good.
My transactional partners can handle all their deals.
There you go. I forgot about that point. Yes.
You can reach me at rslovak, RSLOVAK, at Foley, FOLEY.com. I'm wed to this cell phone, so I typically respond fairly quickly. And thanks for having me on, Ashley. I'm excited about your seeing your personal journey come to this point, having watched what you went through for so many years very closely. I'm excited for your book, and hope that you have all the success that you deserve after dealing with what was can only be charitably characterized as a extremely challenging personal life situation.
Well, thank you very much. You're a dear friend. I appreciate you coming on. And again, thanks, Rob. This has been the Truth Champion Podcast. I'm Ashley Yablon. Hope everyone has a great day. Rob, thank you again. You have a great day as well.
All right, Ashley, you too.
All right.
Thank you for listening to the Truth Champion Podcast with Ashley Yablon. To find out more, please visit www.ashleyyablon.com or follow Ashley on social media. Let us know what you thought of today's podcast or suggest topics you'd like Ashley to cover in the future.